All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning and welcome everyone to a virtual oral argument before the District of Columbia Court of Appeals. Because of the COVID-19 pandemic, we've had to make some changes in how we continue to do our work. We're hearing cases and deciding cases, but at present we're only conducting oral argument remotely. These arguments are being live streamed on YouTube, and a link to the arguments can be found on the court's website. The court staff have worked hard to prepare the judges and counsel to conduct these remote oral arguments, but technical problems may nevertheless arise. And if they do, we ask for your patience. We have 3 cases on our calendar today. We ask counsel to introduce themselves when they begin their argument, and for appellate counsel to let us know how much time you would like for rebuttal. So with that, we'll hear our first case. It's 18 CF 596, Herbert L. Anthony versus the United States.
Good morning, Your Honors. Ian Williams on behalf of Mr. Anthony, the appellant. I would like to reserve 3 minutes for rebuttal.
Thank you, Mr. Williams. When you're ready.
There are 3 issues presented to this court. I would like to focus on what I've identified as the first issue in my brief, in which the court requested supplemental briefing. There is no substantial evidence that Herb Anthony, if he assaulted Mr. Clemens, did so because he was motivated by animus towards Mr. Clemens for calling the police and contacting the police and cooperating with the police in connection with the arrest of Shantice Cole. If he assaulted Mr. Clemens, the reason was clearly and unmistakably animus based on his belief that Mr. Clemens had assaulted Shantice.
Counsel, what you're saying, you're using the word animus, and I'm wondering where animus comes into it. You know, the statute just says on account of. Okay,
but that on account of has been interpreted by this court to impose a motive requirement. And I'm using the word animus. Maybe I should be using the word motivated by rather than animus. But the hostility was based on, and the motivating drive was the hostility for having assaulted and blackening the eye of Shantice Cole.
And why do you say that, counsel? What is you acknowledge that it seems like you acknowledge that the jury could find that that was your client's motive if the assault occurred. What kind of evidence supports the jury's conclusion on that? Did your client admit it, or would the jury be inferring it from the statements your client made on the scene about being angry?
The problem is, Your Honor, there were no statements by my client on the scene suggesting a motive based on the calling of the police. Just on the contrary,
well, my question though is, my question is, you seem to be acknowledging that a jury could find that your client committed the assault because he was angry about his friend being assaulted. Yes. Why do you concede? What evidence causes you to concede that?
The evidence, the testimony of Mr. Clemens, who testified that Mr. Anthony was calling him all kinds of horrible words and saying, "You try hitting me on the eye, you blacken my eye, you see what happens." And
so it's an inference that a jury would draw, not because Mr. Anthony said, you know, at the time of the assault, "Here's why I'm assaulting you." It's an inference from what was said on the scene.
Oh, correct.
Okay. And yes. So the question is, I thought the government, the government does argue that there was evidence that your client was making statements on the scene at the time of the arrest, expressing anger about the arrest also. And the government cites the January 25th transcript at pages 429 to 431 and describes them as the Officer Bewley saying there were people there who were very upset, mad that Officer Bewley was placing Shantice under arrest and not Clemens. In particular, appellant was quite upset, and this is the government's brief, partly with quotes, yelling mainly at Clemens about Clemens getting Shantice locked up. So is that an incorrect description of that testimony, or what's your response to the government's argument along those lines?
That's not an incorrect characterization of the testimony, but what it is it's expressing disdain or disagreement with the police. It's not expressing disdain for Mr. Clemens's calling the police. So
well,
much.
The government, the government, this is a quote, although it has brackets, so I don't have the transcript in front of me, but the government's brief says, appellant was quite upset and yelling mainly at Clemens about Clemens getting Shantice locked up.
And I think the correct interpretation of that, and the only real interpretation of that, when considered against the all the other evidence, primarily the testimony by Mr. Clemens, is it was anger about the decision the police were making. And Officer Bewley testified that there was Mr. Anthony and others were angry that they were arresting the wrong person. Not.
Well, do you think it's a big, your client would have understood that the reason the police, or do you agree that your client would have understood that the reason the police were arresting Shantice, to use that first name because of the other possibly confusing names, was because Mr. Clemens had accused her of criminal conduct? Do you agree that that the jury could have thought, well, your client understood that the reason the police were arresting Shantice was because of what Mr. Clemens told them?
And I would say that's incidental to the fact is that Mr. Clemens would not have been, assuming Mr. Anthony committed the assault, this assault would not have occurred but for the calling of the police. That's a coincidence, just as in Fitzgerald. And the hypothetical posed in one of the footnotes by this court, where the police are present on the scene of an arrest or scene of a police call, and out of zeal, whatever, the officer assaults the person who called the police.
Why do you say the assault would not have occurred if the police haven't been called? I thought it was a line of your reasoning was that, again, assuming the assault occurred, there was evidence indicating that your client was angry about what he believed to be an assault on Shantice by Mr. Clemens, and was saying, I'll show you about punching people in the chin or something like that. And so, if you create a world where the police had never been called, it seems like there is evidence that an assault might well have occurred anyway. And I thought that was part of your point, was that the assault would have happened anyway because your client was already mad about something independent of the calling of the police.
But that was the coalescing point. It's unclear. We don't know if Mr. Anthony would have learned of Shantice's injuries if the police hadn't been called. The police being called created the commotion, which caused Shantice to run out and say, "I've been assaulted." Without that's a precipitating event. It's an event that occurs that brings these events together. So it's not what caused Mr. Clemens calling the police, speaking to the police, making statements to the police. If he made whatever statements he made, we don't know what they were, but we can infer that he was telling the police Shantice had assaulted him. This wouldn't have had the assault. We don't know if Mr. Anthony would have learned about the assault, but for the police to be called.
And I get your argument that in light of Fitzgerald, that if the only line of reasoning supporting the jury's verdict is there's a causal connection in all of this, even if it wasn't a motive of your client, a sort of part of your client's reason for assaulting Mr. Clemens, that that's not good enough. So I get that, but can I ask you the more abstract legal question of, assume for a moment, I know you don't agree with this, but assume for a moment that the evidence would permit a fact finder to think your client had two motives. One was he's angry about what he believes to be an assault on Shantice, and the other is he's angry about what he believes to be the false arrest of Shantice, which is even worse. Like, not only do you assault her, but then you get her falsely arrested by claiming that she assaulted you. Assume that the evidence would allow a fact finder to think that both of those things were in your client's mind at the time of the assault. Do you think that that by itself means that the evidence is insufficient, or how do you think, what do you think the legal rules are that will that a fact finder would have to apply in determining whether to find guilt or not guilt, if that were what the fact finder could reasonably conclude? I know you don't agree with the premise of that question, but taking the premise.
I would say it is insufficient because the whole purpose of the statute is to protect people who cooperate with the police. The presumption is that the cooperation, the assaulter, the person who commits the violence to, this is my word, to punish the person who cooperated, is reporting police behavior, is responding to what could get him or a close friend of his in trouble for an independent crime. Whereas what we have here is there was no evidence that Mr. Anthony was going to get in trouble with the police because of Shantice's arrest. And there's no evidence that Shantice and Mr. Anthony were involved in some sort of conspiracy that her arrest was in furtherance of, you know.
Can I ask you a hypothetical? Just I know that this is definitely not the evidence in this case, but imagine that this case had been just, the evidence was as it is here, except that at the time of the assault, you know, let's say after the swinging of the pipe to the head, Mr. Anthony had said, "That's for punching Shantice." And then, you know, there's the further assault where the other people were involved in kicking him. And after that assault, he had said, "And that's for falsely telling the police that she assaulted you." Would you say, if that were the evidence, would you say that a fact finder that credited that evidence should find, you know, that hypothetical defendant guilty or not guilty?
That raises a very interesting question about the scope of the statute. And I would say under Thompson, the answer is no, because I think the statute is designed to prevent retaliation where it implicates the person who commits the assault. Now, you know, that's, as I said, that's an interesting question, and that would be assuming that that would be sufficient under the statute, then that would be sufficient evidence. I'll concede that.
Well, why wouldn't he be, under your theory, why wouldn't the person be guilty on one count but not the other?
I'm sorry.
Why wouldn't the person be guilty of one count, the one where he says this is for calling the police on Shantice and telling the police that she assaulted you, but not on the other one where the person says, "I'm beating you up now because you beat her up"?
That's not within the latter scenario, Your Honor, is outside the scope of.
Right, but the first one, the former, that's why I asked. Judge McLeese posed a hypothetical where the person evinces clearly two different motives, one motive for one assault and a different motive for the other assault. Okay,
let me answer that by saying factually that would be sufficient. I'll concede that if there is evidence, assuming that evidence is believed, that assuming that's presented to the jury, that would be sufficient. If the statute is interpreted broadly to allow for something beyond retaliation designed to thwart an investigation against the person who commits the act of violence.
Can I ask you about that limitation that you're suggesting? Because I didn't see that in your brief, and that seems a little new to me. And I'm wondering how you square it with the statutory language. The subsection at issue says that, leaving aside its prologue, the defendant commits obstruction of justice if the defendant injures, I'm cutting out things that aren't necessarily load bearing here, any person on account of the person or any other person giving to a criminal investigator in the course of any criminal investigation information related to a violation of any criminal statute in effect in the District of Columbia. So if you're suggesting that there has to be a nexus so that the investigation has to have been of the defendant rather than of some third person, I'm wondering how you square that with the wording of the statute.
I'm squaring that because I have never seen a case where someone's been prosecuted for obstruction of justice based on a communication that has nothing to do with the conduct of the alleged assault, the alleged perpetrator of violence. It's
Can I ask you
always-
another variant of the hypothetical? Imagine, because Judge Ruiz raised an interesting question about maybe in the hypothetical I gave, those are two different crimes, and one of them might not amount to obstruction of justice and would be only assault, and the other might be obstruction of justice. Imagine, again, another hypothetical, slightly different. Imagine that there was just the hitting in the head with the pipe, and after the hitting in the head with the pipe, the hypothetical defendant said, I have two reasons for hitting you in the head. A, you assaulted Shantice, and B, then you got her falsely arrested. Do you think the fact finder who credited that testimony would be required to acquit, or would be required to find the hypothetical defendant guilty? I know, leaving aside the question of the nexus to an investigation relating to the defendant, but just on the question of whether that would be on account of as required by the statute.
That would fall within, that would fall within the scope of on account of, or because of, or in retaliation for.
That's the mixed motive. In other words, when the perpetrator has two reasons, two motives, and one of them clearly falls within the scope of the statute, that's enough.
That's enough, but that's a situation where you have clear evidence
Sure.
of that falling within the statute, and it's equal to the motive that is outside the scope of the statute. The cases that the
So there
government,
needs to be, I'm sorry to interrupt, there needs to be equivalence. I mean, earlier in the argument, you said something about, the police showing up being incidental. And now you're saying that the two motives have to be at least equivalent. I mean,
No.
is it at least equivalent, or does the motive to obstruct have to be the predominant motive?
it does not have to be.
Let me, how about this hypothetical? How about there's an assault, the police get called and take the complainant to the hospital, and the defendant sees all of this, doesn't do anything, then gets a call from the hospital and hears that, there's actually some horrific consequence to the attack, that now the complainant is in a coma, or, has some very serious injury. And the evidence is that then the defendant erupts and says, I'm going to go get that guy, and then goes out and commits the assault, right? In that case, it would seem that the evidence has nothing to do with the police showing up and being called. It's a response to the injury, right? And that seems to be, you could argue, I think, very forcefully, that the predominant motive is really retribution for the actual injury that was inflicted on the complainant, right? And the police showing up is really truly incidental and not the motivating force, because he didn't do anything when the police showed up, right?
Right. I mean, when you say the complainant, you mean the person in Shantice's shoes?
The person in Shantice's shoes.
Okay. I would agree with that. The only reason that
But
that
I'm
would be
trying to
outside
tease
the
out,
scope.
like, where's the standard? Does it on account of require sort of a predominant motive? You were just talking a moment ago about equivalent motives.
Well, I read that was a situation where in the hypothetical, the motives, according to the evidence posed, there was equivalent motive. He said, this is for that, and this is also for This is for A and this is also for B.
Right, so I'm
I-
changing the hypothetical on you to try and figure out where the line is.
In that scenario, it's quite clear that the motive is outside the scope of the statute. This is a beating, this is an assault or an act of violence based on a desire for retribution for causing physical harm. Now, the reason.
But is that required is my question.
Oh, to be outside the scope of the statute? Well, I would phrase it a little differently. There has to be proof, not that the crime was committed for reasons outside the statute, but that it was within the statute. Now that's mincing words based on, the standards of proof and that we have. But I would say there has to be a substantial motivating factor. It has to be substantial. Equivalent isn't, if it's equivalent, then that's within the scope of the statute. If it's not substantial, it's outside the scope of the statute. And I would cite the best case that says that is one that's cited in the government's brief, and that's Banks, where there was the situation where there was a question of what was the motive behind the perpetrator's assault? Was it to rise in the gang, or was it to just get the guy because he didn't like him? And though the judge, the Ninth Circuit found that there was sufficient evidence that it was to rise within the gang, and there was evidence of conduct by the victim's girlfriend that making comments insulting to the gang, and the perpetrator's knowledge of those statements and confrontation of the victim about those statements, the court did say it has to be a substantial factor. Now, it passed the substantial factor test. This case does not pass that substantial factor test. There's, a hint of evidence, I'll concede that there was, that Mr. Anthony was aware of the assault, of the calling of the police. He made some comments directed to that, but that's mostly, according to the witness who's favorable to the government on that point, Officer Bewley, that it was about the wrong guy getting locked up. Though there were comments, according to Officer Bewley, that Mr. Anthony was motivated by, or that he made the comment, he expressed anger about getting Shantice locked up. You didn't hear that from Mr. Clemens, and I know that gets into, the questions of credibility or believability, or whose testimony do you accept on the jury's part. But what's telling is there were no comments by Mr. Anthony, try snitching on me, try calling the police on me. Nothing like that. And
All right, Mr. Williams, we're over time, and I'm gonna let the government respond at this point. So
thank you, Your Honor.
can you mute your mic, and Mr. McGovern will hear from you.
Good morning, Your Honors. Michael McGovern on behalf of the appellee of the United States. It appears that the government and appellant don't disagree with what the correct standard to apply to a subsection A for obstruction charges, and that is that the government must show, and the evidence must be sufficient to support a jury finding that the motive, the report to the police was a substantial motivating factor for the attack or the threat. And in this case—
What do we mean substantial, though? Because substantial is kind of a mushy word. I mean,
Yes, Your Honor.
substantial could be like not hypothetical, right? Substantial could mean not de minimis. Substantial could mean, possibly the predominant. I don't know. What does the government think it means?
Yes, Your Honor. The government would submit that the cases that have interpreted substantial motivating factor have used the terms not incidental or a part of one's general purpose, or that motive was integral to their conduct. And here we believe the evidence does show.
Do we think those words all mean the same thing? Because those could. point you in slightly different directions as well.
Yes, Your Honor.
Or do you really think that coalesces on one coherent standard?
I do believe it coalesces on not incidental, that it is not mere fortuity, that there was also or could also have been a motive based upon the report to the police. So in this case, what's clear is that the evidence shows that the officer heard statements by the appellant while Shantice was being arrested that were directly related to the fact that the appellant was upset that Mr. Clemens was getting Shantice arrested. That was the source of his animus as appellant of it. And because of that,
Well, can I stop you with
It's
your?
not
you-
just that he's, I'm sorry, go ahead, Judge McLeese.
No, I was just going to quarrel with the definite article "the," because you would agree there was also evidence that he was angry that he believed that Mr. Clemens had punched his friend as well. So to say "the" as though like the definite article as though it's exclusive and that was the only seems to me to overstate the matter. You would agree there is evidence. Let me ask you this: if the requirement were sole motive, so that a jury would have to find beyond a reasonable doubt that the only reason that Mr. Anthony committed this assault was because of the arrest, not the underlying what he believed to be assault. Would you think the jury could have found sole motive beyond a reasonable, that the sole motive was false arrest related rather than perceived assault related beyond
Your
reasonable
Honor,
doubt?
on this record, I actually do believe that in a sufficiency review, yes, this court could find that the evidence in this case was sufficient to find that a jury could reasonably determine that it was his sole motive because there was evidence that what upset him at that moment was the fact that she was being arrested. They weren't required to credit Mr. Clemens' testimony that he was upset about Shantice, the allegation of Shantice being hit in the eye, and could have credited instead Officer Bewley's testimony that what he was upset about was the fact that she was being arrested, that there was a report to the police resulting in her arrest in front of him. And so I believe this.
I have a factual question about that. The way you're describing that makes it sound as though from Mr. Clemens, there was evidence about one motive, and from the officers, there was evidence of a different motive, and the jury could have credited one of those sources of evidence and not the other. Is that the way it lined up, really, so that none of the officers' testimony referred in concrete terms to anger about what he perceived to be about what was perceived to be an assault?
Your Honor, I would modify that in two ways. The first is that the officer's testimony was that there was anger that the police were arresting Shantice and not Mr. Clemens. And so that could result in a reasonable interpretation that he was mad about the fact that the wrong person was being arrested. But that still relates back to the report to the police that was being made.
I'm not sure. I asked a question and you modified it so that I'm not sure you answered it. So let me just try again and see. My question is, and maybe I'll try to simplify it. Was there evidence from police officers that in concrete terms indicated that on the scene, Mr. Anthony was upset about the assault as only just as the fact of the assault without more?
Your Honor, my recollection of the record, and I'll point you to the section of the record that you quoted from our brief as where the relevant testimony would be. My recollection is that there was no statement about someone being upset with the assault itself.
No statement from police.
From the police, correct, Your Honor. But rather general testimony that they were upset that Shantice was the one that was being arrested and upset that they didn't want them to lock Shantice up, and that he was upset specifically at Mr. Clemens for getting Shantice locked up. But I would also note that the testimony referenced by appellant from Mr. Clemens himself doesn't preclude a finding that the appellant was motivated by his being upset at what was occurring in front of him. It wasn't simply that appellant said, I'm upset because you hit her. Rather, he was hurling multiple epithets. He was threatening him multiple times throughout the entirety of Mr. Clemens' report to the police. And a reasonable juror could infer from that the entirety of those circumstances as well, that not only was he upset that he had hit Shantice, but that he had, that Mr. Clemens was making the report to the police. So I don't believe that it is reasonable to say that Mr. Clemens' testimony precludes a reasonable inference, even if you credit it, that that the appellant was motivated by the report to the police in his assault with Mr. Clemens.
But yes, he's hurling insults, but where he, to the extent he's specific about anything, he's specific about the hitting her in the eye and not the calling the police or the subsequent arrest. Is that a reasonable inference?
Your Honor,
I mean, given the burden, beyond a reasonable doubt here.
Your Honor, I think the government does not disagree that it would be a reasonable inference, given the statements that Mr. Clemens testified appellant made at the time of Shantice's arrest, that a jury could reasonably infer from that evidence that one of the motives that appellant had when he attacked Mr. Clemens was the fact that he believed Mr. Clemens had assaulted Shantice. But the evidence itself and the statements that he made go from pages 331 to 333 in the transcript, the January 25th transcript. And the context of those statements, right? These statements were being made at a time when Mr. Clemens was actively making a report to the police. And the general description and the specific statements are there, but the generality of what was being said was that he was hurling multiple insults at him, threatening him generally, saying, I will get you, not tied to anything in specific, not saying, I will get you because you hit her, but saying...
Yeah, but I'm sorry to interrupt, that not tied to something specific. I mean, this goes back to Judge Ruiz's question, that what Mr. Clemens, who's the government's witness, right,
Yes, Your Honor.
is specific about is that he's talking to the police, that then Shantice runs out of the building and says, he hit me in the eye. Then Mr. Anthony is responding to that and saying, calling him names and then saying, let me see you hit me in the eye. I'm gonna get you, I'm gonna get you. His I'm gonna get you is directly responsive to you hit her in the eye, try hitting me in the eye, right? And then later, when Mr. Clemens is speaking to the police, Mr. Anthony repeats again, I'm gonna F you up. And that sequence of statements taken together suggests that at least his predominant motive is his anger that Mr. Clemens has beaten up Shantice. Mr. Clemens was already talking to the police, but what precipitates Mr. Anthony's anger, according to Mr. Clemens, is Shantice saying he hit me.
So, Your Honor, I don't know that sequencing comes out as specifically, that it is as clear that he doesn't start yelling until Shantice has said this. It's clear that he is present the entire time the report is being made. It's clear that he's upset. And the officer again testifies that the language he is hearing, the statements that he is hearing from the appellant, is that appellant is upset that Mr. Clemens is getting Shantice locked up. And so while that might be a reasonable inference, it's not a necessary inference that precludes a finding that the motive or primary motive even of the later assault was the fact that Mr. Clemens had reported Shantice to the police. And that would be sufficient under subsection A4
Can I ask you another legal question about how you understand the statute?
Yes, Your Honor.
Imagine, do you think it can suffice under the statute if it's clear that the defendant was going to assault the victim anyway for some non-covered motive, like anger about a perceived assault, but the evidence would permit a fact finder to conclude that the gravity of the assault, the assault was worsened? So that, again, in silly hypothetical world, if the only incident here was the hitting on the head with the pipe, and afterwards, in a statement to the police, let's say, the hypothetical defendant said, well, I mean, I was really mad about what I thought was the punching in the chin. I probably would have slugged the guy if that's all that happened. But when he ends up getting the wrong person arrested by falsely accusing her, I mean, I decided this guy doesn't deserve, this guy deserves to get really punished. And so I went and I got a pipe and I hit him in the back of the head with it. Would you say, assume that a jury believed all of that, and so the conclusion would be the assault was going to happen no matter what because of the other motive, but the additional motive aggravated the assault? Do you think that's covered or not covered? Do you know of any law on that?
Your Honor, the government's position would be that that would be covered under the statute, that the fact that the attack was more severe was motivated by the fact that there was a report to the police, and that was therefore a substantial motivating factor of the assault itself. It may not have been, as Your Honor noted, a but-for cause of the assault generally, but it would have been a substantial motivating factor for the assault and the gravity or severity of that assault, and so therefore would come within subsection A4. If there are no further questions, the government would rely on our brief for our remaining arguments and ask that you affirm the convictions below.
Thank you, Mr. McGovern. Mr. Williams,
Thank
we'll give
you,
you a
Your
couple of
Honor.
minutes in rebuttal.
Thank you. One very important point I want to emphasize is there was the question posed to the government about whether or not there was any testimony by the officers that there was motive based on the assault. And clearly, I would submit that there is. It's not explicit, but it's more that it's very, very strong implicit evidence, and that's the testimony that Officer Bewley's testimony that Mr. Anthony and others were angry that the wrong person was getting arrested. Why would that implies that Mr. Clemens should have been the person arrested? Why would Mr. Clemens be arrested just for calling the police? They're protesting that Mr. Anthony is protesting that the lack of Mr. Clemens should be arrested because he assaulted Shantice. He's expressing a motive. That's motive that comes out in the police testimony. There's no testimony by the police following up on Judge Easterly's hypothetical or question.
I'm trying to understand why that argument helps you, right? Because certainly we don't want individual citizens making decisions about the rightness or wrongness of arrests and then engaging in vigilante justice according to that determination, right? So, they think that the wrong person was arrested. I mean, I'm trying to figure out why that wouldn't bring you right under the statute.
Because the wrong person is arrested rather than the right person. The right person Mr. Clemens is the person who should be arrested. What has he done to warrant
Right, but if
an
you're
arrest?
my very basic point is, if you're acting because you think that the wrong person has been arrested and you're responding to that, why doesn't that constitute obstruction under 722A4? I mean, just straight up.
That's a police mistake as to who should be arrested. But by saying the wrong person's getting arrested, it's saying you assaulted Shantice. you're the one who should be arrested for assault. You're assaulting Shantice, then becomes the motivating factor for the act of violence that follows. Yes, it's vigilante justice under the hypothetical, but it's got nothing to do with the calling of the police. It's the motive is you assaulted Shantice.
But Mr. Williams, isn't there an inference the jury could draw from that, that the reason why Mr. Anthony thought, and as so did others apparently, that the police were arresting the wrong person, meaning you don't have the story right as to who did what to whom, right? Who started this? And so the inference is, well, and the reason why you don't have the right story or the sequence here is because you got it from Clemens, who called you. Isn't that the link back to the statute and the on account of?
No, that's the incidental knowledge of what happened based on the police are there. That causes Mr. Anthony to know that there's been an assault. And it's still the assault that is the overwhelming motive. By saying you arrested the wrong person, you're saying this man, Clemens, committed an assault.
Right.
Therefore, I'm going to assault him for assaulting Ms.
Shantice. Yeah.
I
That's
mean,
that's clearly one possible way of looking at
that
it.
is the substantial motivating. The government and we're all in agreement that substantial motivation is part of it. It can't be de minimis. Under the facts of this case, the testimony of Mr. Clemens, that was very clear, and there can be no discrediting of Mr. Clemens's testimony on this. He was the sole witness to the assault. So the jury against him. So the jury clearly accepted his testimony on that. It's inconceivable.
Well, Mr. Williams, I guess I do that. I'm unsure about that. We have said that a fact finder can credit testimony of a witness in part. And so I think it's at least a possibility, whether how realistic a possibility it was here, but it's a possibility permissible for the jury to say, well, we believe Mr. Clemens about one thing, but we don't necessarily believe him about another. Wouldn't that be within the jury in general? Isn't that within the jury's power to credit testimony in part of a single witness in part, but not in whole?
In general, yes, it is. However, in this case, he was clearly accepted. His testimony was, and he made it very clear that Mr. Anthony had said, I'm going to get you because you've assaulted Shantice. Try blackening my eye. No testimony that try snitching on me, try snitching on, that's what you get for snitching, nothing like that.
Well, your opponent argument, I mean, it's funny because it's sort of the flip side of a point you're making. One of the points you make is that the police testimony about the reasons for the inferential reasons for the assault is a little different from Mr. Clemens' testimony. Mr. Clemens is talking about, the statements about punching and all of that. The police are talking more when they, about complaining about arresting the wrong person. And if in fact the jury viewed those as somewhat different accounts of statements that are happening at about the same time, then it might be that the jury would be free to pick one of the accounts over the other and on that issue, rather than, so why couldn't the jury have said here, well, if we believed Mr. Clemens about what was being said there, it sounded like what was really getting Mr. Anthony mad was the perceived assault on Shantice. But if we credit the officer of the testimonies, it seems like what he was really furious about was they were getting the wrong person arrested. They're arresting, Mr. Clemens is getting the wrong person locked up. And if the jury said, well, okay, we're going to resolve that by believing that really the version of the officers is more accurate, then, well, first, do you agree that the jury could reasonably have perceived a conflict and picked one of those versions over another?
Ordinarily, yes, but in the circumstances of this case, no, because it was no testimony about Mr. Clemens' testimony was particularly compelling about what was said to him and what the motive, in terms of shedding light on Mr. Anthony's motive to perpetuate an act of violence a couple of hours later. And the officer's testimony that the wrong person means Mr. Anthony is expressing anger towards the police because an assault occurred by Mr. Clemens. And that's what's motivating him later on to assault Mr. Clemens. And, there was a mixed, Fitzgerald was a mixed motive case. This is a much stronger, in Fitzgerald, there was a question of what was the motive, whether it was to retrieve property or to punish the victim for being a snitch, for calling the police. The evidence was overwhelming that it was retaliation for calling the police. It's just the
All right.
opposite here.
If I can just ask one last question, just to make sure I have the record straight here. Officer Bewley expressed his opinion of what he thought Mr. Anthony was upset about. Did he actually testify that Mr. Anthony said things? Did he testify about words used by Mr. Anthony that expressed that he was upset about the wrong person being arrested?
That was, if I recall correctly, that was, there were no specific words no testimony by Officer Bewley restating specific words used. It was, I think he was upset because we were arresting the wrong guy
Okay.
or the wrong person.
We'll take a careful look at that record. Thank you, counsel, very much for your arguments, and the case will be submitted.
Thank you, Your Honors. May I be excused?
Yes.
Let me make sure I do this right.
Good morning.
Good morning. I'm going to try to put my screen up behind me, if you have time for that.
Your
I'm going to
Honor,
go ahead
I'm sorry.
and call the case while you're working. Our second case today is 19 BG 554, in re Paul S. Haar, and counsel, Mr. Schumack.
Yes, ma'am.
When you are ready, please introduce yourself for the record and let us know how much time you'd like for rebuttal, please.
You can see me fine and hear me?
Yes, we can.
I believe I'm ready.
Please proceed.
You want introductions first?
I would like appellant to go ahead and begin.
May it please the court. I'm Daniel Schumack, counsel for respondent Paul Haar. I would like to reserve 5 minutes for rebuttal today. This case is before the court for review of the disciplinary system's handling of 2 bar complaints. The Moya bar complaint filed in 2012 and the GER complaint filed in 2013. I will focus my initial remarks on an overview of how we got here. Then I'd like to
Counsel,
proceed with-
we're familiar with the record and the procedural history. So given time constraints, I think it would be more helpful for you to go ahead and jump right in to discuss whether the rule violations were appropriate and whether the discipline is appropriate, the suggested discipline.
All right. Well, as you know,
And for my part, I would be interested in hearing about whether or not we should conclude that the commingling and misappropriation of the GER fees were reckless or intentional.
all right. Well, let me suggest to you that a little small bit of discussion about the Moya docket is important because it helps to set the timeline that's relevant to the second docket, the GER docket. Our position is certainly that there's nothing actionable on the Moya docket, but the Moya docket involved a refund that was made in November of 2012. The testimony in the case is that Mr. Haar was not aware at the time he made that refund that the Mance case existed. The testimony is that Mr. Haar did not become aware of the Mance case until meeting with the Practice Management Advisory Service in December of 2012, at which point he was there seeking guidance on law office management procedures to try to avoid another bar complaint that was like the Moya complaint. Mr. Moya wasn't complaining about a Mance violation. He was complaining about the
Right. Mr. Schumacher, we understand that Mr. Moya was not complaining about a Mance violation, but I suppose if you're interested in looking at the Moya procedural history to help us understand whether your client's conduct was reckless or intentional in this case, we can certainly look at the fact that your client was told by his associate that he had to repay Mr. Moya from his trust account, right?
There's no dispute.
And so he did, right? In November, he moves funds into his trust account and then repays Mr. Moya from his trust account. And I guess my question for you on that subject is, if you were told you have to move funds into a trust account to repay someone, right? How does that not raise more questions in your mind, I suppose, right? Because your trust account presumably contains entrusted funds. And if you are told that you have to repay a client out of an account that only holds entrusted funds for other clients, then where are you supposed to get the money to repay the person seeking the refund from the funds in the trust account, right? Those funds in that trust account belong to other clients. You cannot use those funds to repay the client who wants the refund, right? So under my understanding of your factual account is that Mr. Haar was told, I have to repay Mr. Moya from my trust account. And he had to have known, I don't have Mr. Moya's funds in my trust account. I have funds for other clients in my trust account. So he has to take his own money from his operating account and put it into the trust account, which means that he's commingling funds under this advice as he understands it, which would seem to me to raise more questions than answers. Does that make any sense? I don't understand why he didn't say at that point, wait, is there a bigger problem here? I don't have entrusted funds in my trust account to pay Mr. Moya because right now, under my narrative, I know nothing of Mance, and I believe that the Moya funds that I got paid are mine. So why does that make any sense? Or why is the repayment from the trust account in the Moya case helpful to you?
Well, I don't think it is helpful. And certainly the hearing committee didn't think so. But our take on the record was that the hearing committee made certain assumptions about the discussion between.
I'm not interested in the hearing committee's assumptions. What we have is facts, right? We have facts. We have your client's testimony that he was ignorant of Mance for 3 years after it was decided, that he then did research when he was requested in the Moya case as to how to make his client in Moya whole, how to do a refund. And he was told, you have to pay the refund from a trust account. And he didn't have those funds in the trust account because he had put them in his operating account. He thought those funds were his. Right?
Yes,
He
so-
was operating under a pre-2000 understanding of the law. So under his understanding of the world, he put his own money into a trust account, which is the definition of commingling. And I'm asking, why didn't that raise questions in his head? And why is that? Why did you want us to look at the Moya facts this morning when you asked us to look back at the Moya case?
Okay, so I may have given you a misimpression of what I was asking you to do. I was prepared to argue the GERD docket and argue the opposition to Bar Counsel's position. Bar Counsel believes today that the refund in Moya is significant because the committee glommed onto that.
Okay.
Bar Counsel wasn't arguing that.
I'm not asking about Bar Counsel's argument right now. Do you have any explanation as to why that should not, the advice that you have to repay Mr. Moya from entrusted funds should not have raised questions in your client's mind as to how he was keeping funds and whether or not he was being asked to commingle or whether he had already misappropriated funds?
Sure. Okay. So at the point when the associate, Mr. Miller, reported back on his research findings, the record shows that Mr. Miller says, whatever refund you want to give here has to come from a trust account. You have to put it through a trust account. That's it. Now, the record shows that Mr. Har had no money in a trust account prior. So this was not an instance of commingling any new money with other money that was in trust. Further, I would suggest to you that as a matter of law, from the moment that Mr. Har decides he's going to give the client a refund in any amount, that refundable amount can't be considered a commingling item. He's willfully giving up an entitlement to that money.
But so let me try the question a different way and not focus even so much on this scenario, but just logically speaking, if a lawyer is told a client wants a refund of a flat fee, and so the lawyer is also told you need to pay that from a trust account, can that logically imply, whether your client figured this out or not, or should have figured it out or anything else, does that logically imply that the flat fee was entrusted funds? Does that advice, is there any other possible explanation for that advice other than that the flat fee ought to have been viewed as entrusted funds, at least at the point when it was unearned?
Well, I think you can reach the same conclusion that the board reached, which is that it could have meant almost anything.
Well, could you be concrete about how it, give me an explanation of why that could be required for funds that were not entrusted?
So
any possible explanation?
as far as my client was told, this had nothing to do with any amount of fees.
You're not really
It's
answering
just-
my question. I don't really care what your client was told. I'm just asking in the abstract, give me a hypothetical where it would be required to make a refund to a client out of a trust account for funds that were not entrusted. That's just an abstract question. It has nothing to do with your client or anything else. It's just, can you give me an example of how it could be possible that that would be a legal requirement for funds that were not entrusted?
Well, one thing is it could have been that the associate was wrong, that the advice he gave was wrong, that it didn't need to come from a trust account.
As it
How
turns
is
out,
that helpful to
Yeah.
your client if he is the managing partner of the firm and he's getting advice that seems on its face wrong? Then
No, no,
doesn't he,
I'm
as
not
a
telling you it was
supervisor, have an
wrong.
obligation? I mean, if we're trying to figure out why he acted reasonably going forward after doing what his associate told him to do, right? Then you need to give us an alternate explanation for, oh, these are entrusted funds and they should have always been in this account, right? And the only explanation thus far you've given us is, oh, my associate gave me flawed advice, which I'm not sure allows you to make a reasonableness assessment for his behavior going forward, because he's responsible for what the advice that he's getting from his associate, and he needs to do his due diligence.
So I'm not making an
Judge
assertion.
Ruiz, you're muted.
Pardon?
So sorry. I just want to add that, and Mr. Har followed his associate's advice. So it must not have seemed to him to have been so completely wrong.
Oh, of course. And I'm not saying it was wrong. I was asked, are
No,
there
it wasn't.
scenarios? And one scenario could be that it wasn't good advice. But
no, but
what
my
I-
scenario wasn't, my scenario was what could your client possibly have been thinking? My question was, because that is a possibility, that wouldn't have been a good line of thought, because as it turns out, the associate's advice was right. And if your client had been thinking that, your client would have been wrong. But my question was very abstract, and it's just in law, under the ethical rules, can you give me any explanation that would be right? That would be, I have been told that I need to pay my client some money from entrusted funds. Can you give me any actually correct legal theory about how that could be true, but the funds themselves that you're refunding not entrusted? That's my question. And if the answer to that is no, then it is arguably damaging to your client in the way that the hearing committee thought, that this was a big red flag, should have been. Again, your client may not have thought this through, but it should have been a big red flag that, wow, something's going on here that I didn't understand, because I thought this was my money. And if I'm going to give a refund for something that was my money out of the goodness of my heart, I'll just pay it out of my operating account. But if my associate is telling me, no, these are essentially, it seems to me, the associate is logically saying these were entrusted funds. That could be the only explanation I've heard yet about why that would be correct advice. And if that's what the associate said, then your client is on notice earlier that there's a problem here. And that's why we focused on this aspect of the Moya matter, and why the hearing committee did too.
All right, I can think of at least one example then that I believe addresses your request. And that is, if you receive money from a client and you believe you have performed the work and earned the money, and you have properly had that money outside of a trust account for one of two reasons: either under today's law, you had a Mance waiver, or you had actually gotten paid by your client for an invoice that you sent to your client, right? You get paid, you're entitled to believe it's your money. You're entitled to put that in your trust account. If the client changes their mind 2 months later and said, hey, I took a look at your bills, I want half this money back, you don't have an obligation to put that into trust in order to resolve the dispute. You might opt to send your client a refund, in which case you could send that from your operating account. But there's no current requirement for you to impound money and escrow money just because your client raises a late dispute. We
Your
do have a
example, I think,
market-
I think your example is the opposite of what I was asking for, because I think your example is saying that in that scenario, there would be no reason to put the refund back into a trust account. So what I'm asking for is there any possible correct legal explanation for why your client would have to take this money that he believed was an advance payment, why he would have to, before he refunds it, put it into a trust account, except that it was entrusted money? And I'm just trying to figure out, when would you ever put money into a trust account to then refund it if you already have it? Unless you were mistaken that it was entrusted. And that's what someone's essentially telling you, is you thought this was your money, and now you're going to give it back. But if you give it back from yourself, it's not right, because you're not doing things in the proper way. I'm struggling with having any reasonable conclusion anyone could draw about why that would be correct advice about an obligation, except the funds were entrusted in the first place, and that your client was wrong in thinking otherwise.
I don't, in this argument today, I don't have a better example to give you. Certainly, if I can come up with one, I'll be happy to submit one in writing subsequently. What I can tell you.
I'm sorry, go ahead.
What I can tell you is the client did not contemplate that there was anything wrong with the way he had handled his money. There was nothing here that triggered him to think, the way the committee concluded, that he must have known that he had different obligations at that moment in time.
Well, let's then start from there and assume no red flags were raised. In December, right? So your client repays the money to Mr. Moya or is told, I suppose, that he needs to put money into the trust account to repay the funds. Then he receives the GER flat fee of $10,000, which he says is an unusually large amount of money for him to receive. And weeks later, he has the practice management advisory service instructor come to his firm and give a training about how to handle client monies that includes information about Nance. Is that correct?
Well, the purpose of the meeting, as far as
I'm just saying, I'm not asking about the purpose of the meeting. I mean, I have his testimony about what the purpose, he understood the purpose of the meeting, but Nance was discussed.
That's correct.
He was told about Nance, right?
Yes.
And from then on, from December of 2012 through, I believe, November of 2013, he continues to hold the GER funds in his operating account. And I'm trying to understand how, once he has been told about Nance, how he can reasonably continue to keep the GER funds, the funds that, the amount of money that he has not earned in his operating account, because Nance very clearly says you can't do that. Unearned funds, unearned payments have to be held in trust. So why is your client not at a minimum reckless, if not intentionally violating Rule 1.15 at that juncture from December of 2012 through November of 2013?
So we have in the record the testimony about what he learned about Nance from Mr. Mills. We have in the record that Mr. Mills was describing prospective needs.
Where is that in the record?
That's in Mr. Har's testimony, and the board report cites to it.
I'd love to see the page site for the testimony, because I didn't see testimony saying that Mr. Mills said that Nance was prospective as to the attorney. That only once an attorney learns of Mance do they have to come into compliance with Mance. I didn't see that testimony.
That was
If I'm
not,
understanding what you're saying.
yeah, that was not the precise testimony. He's, what respondent testified to, what Mr. Hart testified to was that Mr. Mills gave him prospective marching orders. This is what you need to do to get compliance with Mance. And he went
Can you
about,
give me a page number?
if we could pull that for you in our rebuttal, I think that would be helpful for me to carry on here with the remaining time that I've got left.
Could I just ask you though on that, how could I understand the issue relating to the Moya matter about whether Mance, the way in which it was a prospective and whether it meant right after Mance was decided, people needed to unravel previously accepted payments. And that's a really interesting question that we may not have to fully grapple with here. But how could anyone think that if in 2009, the court said you can't accept advance payment that's unearned and put it into an operating account, you need to have it treated as entrusted funds. How could anybody think, oh, but if in 2012, I misapplied that rule and I took operating fund, I took what's entrusted funds and I put them in an operating account. How could you possibly think it would be reasonable that it would be an adequate solution to that to say, well, I'll just keep, money that I should never have had there and commingle it and do whatever I want with it, misappropriate it and the like. It's all fine as long as I don't make that mistake anymore. I mean, I just don't understand how anybody could think that would be a possibly plausible way of reading what one of our opinions requires.
So the testimony here included Mr. Haar indicating that Dan Mills never suggested the need for an audit of open files.
Yeah, I understand. Maybe it's true that nobody spelled that out to your client in terms. I'm just trying to figure out whether, again, whether your client acted recklessly or worse in not understanding that himself. And so if somebody says, there's this Mance opinion, it says that unearned advanced flat fees are entrusted funds. If your client knew that, what I'm struggling with is how is anybody who's told that, how could they possibly think, again, different question with respect to pre-Mance accepted of funds, because that I can see that as something there's a more reasonable debate about. But if 3 years after Mance, I'm a lawyer and I didn't do what Mance told me to do, how could I possibly think, oh, it's just fine. Nobody's telling me I need to fix the problem, so I can just keep money that isn't mine and misappropriate it. That just doesn't seem like it's it's not only is it not a good faith mistake of law and not negligent, it just seems like I don't understand how that is a conceivable view that someone could, you could hold it not in bad faith, I guess, but it seems to me that it's objectively a very unreasonable view. And so can you tell me, you think, explain to me why you think that a court that decided Mance could possibly think to somebody who 3 years after doesn't comply with it, if you didn't realize it at the time, just go ahead and keep the money. Like why would a court think that?
All right, if I could offer two observations here. First off, in terms of where in the record we have the testimony about what transpired with Mr. Mills and the respondent, that's on page 15 of the board order. And it includes the transcript citations as to what he was and was not told by Mr. Mills. In terms of Your Honor's question about the reasonableness of failing to, I think your question goes to the whole audit questions that were part of the cross-exam below. And in the context of audit, Mr. Hart testified that he had no way to know or believe, or no reason to believe would be a better characterization, that he actually had open files where he hadn't already earned the money because so many of his clients paid him in arrears.
So there, I think, I mean, actually in both instances, I think you collide into the record, right? Because the testimony here, well, let's backtrack first to what Mr. Mills told your client, according to your client. I'm looking at your client's testimony on page 166 of the transcript. And the question is, I believe, I'm not sure if this is on cross or whether this is your direct. And Dan Mills had advised you about Mance, and your client says, that's my understanding. And then the question is, and your firm began to incorporate Mance type protocols? Yes. And now, oh, this is on cross. Your counsel asked why you didn't put the GER funds into a trust account. And your client says, I did not move retroactively. He does not say anything about what Mills told him to do or told him that his actions should only be prospective. And then he's asked, well, why did you only move proactively? And he starts to give an answer that, well, we'd already done all this work. We thought that we had earned the funds, indicating not that he wasn't thinking about doing an audit, not that he wasn't thinking he needed to be concerned about the GER funds in light of Mance, but that he thought actually he was in compliance with Mance because he had earned the funds. But then there's kind of an interesting back and forth with counsel interjecting. And finally, we get to a point where you say we're willing to stipulate that actually he'd only earned a very small amount of funds, which suggests, I mean, he's getting this amount of money, $10,000, which is significant to him and unusual. And you stipulate that he had earned a very little portion of it. It seems like doing a Mance audit to make sure that you only take the very little that you've actually earned and put the rest in entrusted funds for something that you just got a few weeks before this training would not be difficult to do and might have actually been top of mind. And just to continue with looking at the record, your client testifies, and now I'm back on page 123, that he didn't understand Mance, and honestly, I didn't understand Mance, and had I done, I would have complied immediately once I knew about it. But he did know about it come December when Mr. Mills told him about Mance. And so I'm trying to understand why he didn't comply once he had actual knowledge of Mance. Mance is very well written, and it's very clear. And it says that prepaid fees, flat fees, are entrusted funds and must be held in trust accounts.
If I may, the stipulation you just referenced, which is around page 169 or 70 in the transcript, that's me jumping into the transcript after disciplinary counsel had cross-examined my client on the file notations that displayed the amount of work done. So we were stipulating essentially that the file showed—
I don't really actually see any cross-examination about notes. It seems like you're trying to rehabilitate your client's testimony that he thought that he had actually earned a large percentage of the GER funds, which is his testimony at 167, and is his explanation why, after learning about Mance, he didn't put the $10,000 prepayment in a trust account.
Well, I can tell you that it may be here or it may be in a separate spot in the transcript, but my client was cross-examined on his file notations and the file notations displayed very little work having been recorded as having been done by the time of December, when they had the meeting in the practice management service with Mr. Mills. That doesn't mean that my client was aware that there was very little work done at that time. It's as we're sitting here being cross-examined with the file in front of him that he can see from the file, and we're conceding that the file showed there was very little work having been done.
No, my point is a very basic one, which is if the argument is now that your client understood Mance to apply to him personally prospectively, I think the record does not support that argument. If anything, the record suggests that your client was told about Mance, that your client says, look, I wish that I had known about Mance sooner, and as soon as I knew about it, I was going to comply with it. And then he suggests that he doesn't put the GER fees in because he's got some sort of Mance type reasoning for not putting them in the trust account because he thinks that he's earned them, which is incorrect. But that there does not seem to be any record evidence that he didn't understand Mance to apply to the GER fees.
Well, the record here is not going to get any better than what it already is. I would suggest to you that the board handled this in a way that we're happy with. And obviously that's different than the way the hearing committee viewed it. And you are suggesting that you're taking the same view as the hearing committee. I would ask you to take a close look at the way the board reasoned this out.
Well, our review of the legal issues and whether your client acted recklessly or intentionally is a legal question ultimately, right? And the facts that I'm pointing out are either undisputed chronological facts, or I'm pointing you to parts of the record that memorialize your client's testimony. So for sure, we defer to the board's findings of fact, and the board adopted the hearing committee's findings of fact and then supplemented it with a few of its own. But as for the GER matter, its findings are very minimal. It's additional findings. It's one paragraph, right? So we defer to the findings and we make de novo legal conclusions. And I'm trying to see if there's any reason why we should not determine that your client acted at least recklessly in handling the GER funds.
So the board is finding that my client did not know that he needed to do some retroactive analysis or audit.
And that is based on what? That is
Well,
based on what? Because I'm interested in kind of a bigger picture question here, which is the court issues an opinion in 2009 that says unequivocally, flat fees are unearned fees and must belong to the client and must be kept into a trust account. Must be kept in a trust account, right? And you cannot use that money, obviously, until you have earned it. And that is made prospective because we had not clarified that understanding of 115 with respect to flat fees. That is made prospective as to Mr. Mance, right? As to Mr. Mance, because he did not know about this interpretation at the time that he acted because we had not said it. But we do say it in 2009, and now we are down the road several years. And this notion of using the word prospective in Mance to somehow mean that you don't have to conform your conduct to Mance's requirements, even after you are well aware of what they are. What is the legal basis or reasoning for that, particularly in the disciplinary context, and particularly when we're talking about client funds and protecting client funds, which, as we know, we consider to be one of the most core obligations a lawyer has. I mean, if people are just going to say, well, I didn't know about the opinion, or I knew about it, but I didn't understand it correct. I mean, is somebody going to come in with this same defense 25 years from now? How do we, as a system that is trying to protect client funds and set out clear rules and have them enforced, how do we go about dealing with this issue?
Well, unfortunately, when you're asking the bar to respond to clear rules, one of the largest problems in this case has always been that the rule is not clear on its face. It wasn't clear on its face in 2009, and that's why you all had to issue the Mance decision. If you look at footnote 4 in the board's report, the board suggests that there's a need to amend the rule, or at least amend the comments, to alert the bar that Mance exists. Here we are, we're 2020, there's been no action by the Rules Committee to amend Rule 1.15. We still have a rule that on its face doesn't tell the bar what Mance says. So I would suggest that the best way for the bar in this court not to have to deal with this same type of problem indefinitely are to do some of the things that our expert, Mr. Clark, testified to. That could mean amending the rule. It could mean a certification that you need to file when you renew your bar dues every year, which is something that exists in other jurisdictions, that you're aware of this rule regarding prepaid flat fees. But we know this problem is still going on because you're still hearing cases on this.
That's not my,
Counsel,
that, go ahead.
go ahead, Judge Ruiz.
No, I just don't think that's responsive to my question, which is that you can claim ignorance and or reliance on somebody else when you actually have an opinion that you can read and say, all right, or I now know what I need to be doing, and you just don't do it. I mean, I just don't understand how that makes any sense from the point of view of us, of the court, in trying to make sure that our judgments and interpretations are clear and are enforced and followed.
I will piggyback on Judge Ruiz's question and say, not only would I be interested to hear from you why that would make any sense, I'd like to know how that can be reconciled with our decisions, where we talk about the decisions that we render in terms of giving the members of our bar notice, right? So in the matter of Adams, we say, talking about Hines, the court put the bar on notice that henceforth disbarment would be the usual sanction for misappropriation, right? We use the word notice all the time in our opinions. And I think it's not even the implication, the expectation is that members of the bar read our disciplinary decisions. We write them carefully, thoughtfully, to give guidance, and to have a defense that, well, I just didn't read it, and I didn't even think, I kept up to date on my area of interest, immigration law, but I just assumed that ethical rules and law stayed frozen for me, that I was grandfathered in time to 1983, and I did not have to educate myself or read any of the Court of Appeals opinions. It's not a compelling defense, and it's not consistent with our case law.
Your Honor, there's no doubt that you publish an opinion and it puts the bar on constructive notice that the rules have changed. But there is a wide difference between constructive notice and actual notice.
There is, which makes it an interesting case in your case to be talking about constructive notice and complaining about inadequate training for lawyers because your client actually got personalized training and actual notice of Mance in December 2012. So honestly, I don't understand what the expert testimony had to do, why that was relevant in this case about how, anecdotal reports of other members of the bar being unaware of Mance had anything to do with this case because your client had actual notice of Mance. And presumably, as a member of the bar, he's capable of reading Mance himself and understanding it. As I've said, it's very clear, it's very well written.
Ms. Lyman said that they were going to bring up the Bernard Gray case that we offered, that we decided earlier this year, I guess February. And I think that has some language that goes to this issue. I don't know whether you want to address that now, Mr. Schumacher, or you want to wait until Ms. Lyman has spoken and do it on rebuttal. But I want to give you a chance.
I was hoping to do that on rebuttal because it's not clear to me how they intend to use it.
Well, I will read you a few things. One is that it talks about whether the person had, what was important in terms of recklessness. And one was that the person had actual knowledge. Then second says, we have never held that an attorney's assertion of a good faith belief that he was using his own money will preclude a finding of reckless misappropriation where that belief was objectively unreasonable. And I think that's what we've been talking about here, is whether this was objectively reasonable belief and conduct, given the opinion, given the time that had run since the opinion was issued. And then there's a third point that's made, and it's that the only reason that the respondent in that case, Mr. Gray, could reasonably claim that he believed in good faith that the money was his is that he acted in ways that were consonant with that belief. And I guess that goes back to, in connection with the Moya case and the having kind of routed the refund through the trust account, which is not consistent with a belief that those monies belong. So I don't know, I don't want to take Ms. Lyman's argument away from her, but since this letter came to our attention, I of course went back and reread Bernard Gray to see what the parts of it are that might be relevant here. And I would think that those are the parts that are relevant here.
Well, I'm happy to yield to Ms. Lyman if my time is up. I can't actually see the clock in your display.
Okay.
Well, you are out of time, and if that's what you would like to do, we'll give you a few minutes on rebuttal and we'll hear from Ms. Lyman.
Do I still have my 5 minutes that I attempted to reserve?
We'll give you some time.
All right, thank you.
Morning, Your Honors. Jennifer Lyman. I am in the role of Special Assistant Disciplinary Counsel because I've actually retired from the Office of Disciplinary Counsel. But I am representing the office for this case. There are a number of different routes to get to recklessness in this case, and a number of them already have been discussed, but I do want to emphasize that the underlying historical facts are in some ways put at issue by the board's report, which relies in its conclusions of law, not in its fact statement, but in its conclusions of law, on a number of statements undercutting the factual findings made by the hearing committee, which saw Mr. Haar testify, which was his own election, because the majority of the facts needed for the case were already admitted by stipulation. So Mr. Haar chose to testify and chose to put forth this claim that he was basically tabula rasa with respect to his obligations to put his flat unearned fees into trust. And and the hearing committee's findings were entitled to deference because they were supported by substantial evidence in the record. One
Well,
of
do we
the-
have to get to deference if, I mean, can we just parse this very cleanly and say the hearing committee made findings, the board adopted them, right? In its findings, we can get to how it analyzed them and plugged them into its legal analysis when we get to the analysis. But as far as what the facts were, I mean, most of the facts are undisputed. Can we just say that? Or do you think that we have to get into some analysis of clearly erroneous fact finding and who gets to make credibility decisions? I don't see a need to go that way here.
You don't have to, it's true. The one point that I wanted to make about that was their objection to the inference that the hearing committee drew that Mr. Haar's idea, his understanding of his trust obligations had changed after he received advice from Mr. Miller. And the court basically addressed those issues in the presentation by Mr. Schumack. So I don't need to go much further. It's all spelled out in our
Right.
brief, but I think that's an inference.
If we can bypass that inference, right?
Yes.
And we can say, if you have an associate who tells you you have to repay a client from your trust account and you don't have those funds in the trust account, then reasonably that should cause you to have questions, at least trigger a duty to inquire, if not give you the understanding that Judge McLeese was articulating, that it must be that these funds should have been in the trust account, right? These are entrusted funds or should have been entrusted funds. So
Agreed.
it seems to
And
me what inference he drew, we just need to do a recklessness analysis, right?
agreed. Agreed.
Okay.
And the recklessness analysis proceeds from the fact that he goes through the motions to make the appearance of the refund coming from his trust account. It's a trust account he has not used. In fact, he's kept $100 in it. We don't know where that $100 came from, but other than that $100, he has not used it at all until he puts the refund through it. At that point, Mr. Gore was in the process of accepting Mr. Gore's case. Mr. Gore pays him about a week later, and he puts the money directly into his operating account, although obviously he hasn't earned it, and most of it is gone pretty quickly. I want to address briefly this notion that he somehow had to go back once he learns of Mance from Mr. Mills. He has to go back and do this audit, which is a word that Mr. Haar and the board have used. There was no audit. There should have been no audit required, because no matter what his understanding of his Mance obligations had been up till that point, he certainly knew that the rules required that if a client, if the relationship fell apart, he was going to have to refund the client whatever money he hadn't earned. So any lawyer who's taking flat fees and isn't keeping track of the money that has been earned or not earned since 2000 is falling short of his obligation to refund the money if the relationship falls apart before he's done the work. So he had that obligation already. We shouldn't have required any new bookkeeping or issues on his point. The recklessness point goes to the question raised in Gray, and it really identifies two parts to this reasonable good faith finding. The good faith part, the belief part, goes to the sincerity of the belief. And that is where, in this case, the hearing committee found, based on Mr. Haar's demeanor when he testified, that it could no longer completely credit the sincerity of his belief after Mr. Miller advises him to put the money through the trust account for the refund. But the second part, which is really independent of the first part, is that belief has to be reasonable. And well, however reasonable it may have been for Mr. Haar to put Mr. Gore's money into operating account 3 years after the Mance decision in the first place, it certainly wasn't reasonable, wasn't objectively reasonable for him to keep it there long before he'd earned most of it, once he learned of Mance a few weeks later. And he goes further. He actually takes a CLE in March of 2013 or May of 2013 on the handling of trust accounts. And he still keeps Mr. Gore's money in his operating account until he gives the refund almost a year after the representation was undertaken. So the recklessness question is answerable on either prong. It's answerable because the sincerity of his belief that he was entitled to take and use Mr. Gore's money is brought into question by the fact that he knows he has to do a refund from the trust account.
The first of those bases, though, does seem to wrap us back around into the relative functions of this court, the board, and the hearing committees on questions of credibility. Because on the one hand, it seems to me quite logical to say, if the hearing committee is taking live testimony and looking at demeanor and ends up concluding at the end of that, the lawyer is claiming he or she didn't know something. I'm finding, the hearing committee says we're finding, as a matter of fact, that the lawyer actually did know something at that time. That seems like a pure question of historical fact, and it seems like that the board ought to be required to defer to it, and that we would enforce that requirement if the board didn't, and we of course also defer to it unless it was unreasonable in some way, but it would be viewed very deferentially. But your opponent, there are some confusing counter currents in our case law. There is this doctrine about ultimate facts, and we don't defer on ultimate facts. And there's a case your opponent relies on called In re Bradley that seems to be not deferring on a question that is similar to that. And so I don't know that I necessarily want to bog us all the way down in those questions, which I find complicated and confusing. But I do agree that in order to accept the first of those two rationales, we might have to start delving into those topics.
Well, the first answer is you can decide the case without having to go to both prongs. You could go just to the one objectiveness prong. But on the other prong, yes, I do think that calls into question this fact-finding issue. And I think Bradley has often been used to signify something much broader than it actually did. Bradley was essentially a sufficiency of the evidence case, because what the board and ultimately the court did when they rejected the hearing committee's findings that the lawyer seemed honest in thinking that she had been telling the truth. What the board and the court found, what the court found was that there simply was no evidence that she could have thought that. And so it was really a very narrow question. And it also went to just the question of sanctionable dishonesty, which is an independent aggravating factor in a disciplinary sanction. So sanctionable dishonesty was the question that the court and the board were addressing as the ultimate issue, the ultimate fact issue in the Bradley case. And I think it's been often read more broadly but certainly by the board, to suggest they have some sort of de novo review capability anytime facts might affect the sanction. But of course, that proves too much, because all facts affect the sanction, in that if you don't have any, you don't have a rule violation, you don't have sanction. So
I get all that, but it is the case that we, not just in Bradley, we have this doctrine about ultimate facts. And if knowledge is an ultimate fact relative to whether the misappropriation is of a gravity that presumptively triggers disbarment, it sounds ultimate factish, even though it also seems very much like a pure question of historical fact that would be affected by credibility. And our wording in Bradley seemed more broadly to rely on that, to me, confusing doctrine. So, I mean, I understand the line of argument you're making. I just acknowledging, notwithstanding the point you're making, I still find myself confused about how to fit these pieces together.
I think one way to look at it is like knowledge, like intent, is one of those squishy facts, real facts, that only exist inside someone's head. And so the fact finder inevitably is making an inference about what was in somebody's head when they draw that inference. But the inference drawing function is classically a fact finding function. An inference of the sort that is at issue in this case would support a finding of sufficiency under a beyond a reasonable doubt standard in criminal cases in the District of Columbia. And we cited several in our brief to give examples of the type of inference drawing that is a fact finder's function, because they're the ones who see the person testify. They're the ones who get all the sort of collateral indicia of the level of sincerity and other kinds of nuances about the testimony, which the hearing committee described and referred to in this case as a basis for its fact finding and its conclusion about Mr. Har's credibility. But the recklessness question and the objective reasonableness of Mr. Har's conduct is answerable on the face of just the broadest facts in this case, including the fact that he does not even make an effort to keep up with the disciplinary rules in the case. And the Office of Disciplinary Counsel has, with respect to the Rules Committee, previously tried to get more specificity in the rules. The bar tends to resist it because they don't want to be told what to do in any precise way, and they feel like it might be a trap and catch them out. But more specificity in the rules would not have helped out in this case, because Mr. Har wasn't reading the rules. He wasn't reading Mance. He wasn't reading the rules. He wasn't reading anything about ethics, and he testified to that effect. So that is really fundamentally, and I think Judge Ruiz is right in saying the court has to be concerned about the broader systemic question here. Lawyers have to be responsible. Of course, everybody isn't reading every what used to be called a slip opinion that comes from the court, but people have to be paying attention to the rules for licensure, or it's not safe for the public to rely on that license as an indication that the lawyer they hire is somebody who will follow those rules and protect their funds. On that ground, Office of Disciplinary Counsel takes the position that the court should review the board's recklessness finding de novo and conclude that Mr. Har, in fact, was reckless in misappropriating the funds in this case.
And to be specific, if we wanted to avoid the credibility finding and the subjective good faith thing and go only on the objective reasonableness, or in this case, according to you, unreasonableness of the conduct, what specific, you've mentioned no effort to keep up with the disciplinary rules, did not read Mass. Is there anything else that you would point to specifically that is uncontested in the record?
Well, clearly all the behavior once he hears about Mance from Mr. Mills, the behavior in continuing to treat Mr. Gore's money as if it were his own, when he's had clear notice that it does not belong to him. It never belonged to him. The fact that he interpreted it as belonging to him before he'd earned it is what is reckless under all the circumstances. And obviously the fact that this particular lawyer had the personal message in 1997 under the same rule, although it was a different aspect of it. Money handling matters. Handling the client's money, even when it's only arguably the client's money, matters. And you have to pay attention to this or you risk a very serious sanction. And in that case, he just got a suspension, but he was on notice. And the rest of the bar was on notice, and the court specifically said so in that case. The rest of the bar is now on notice that this dispute doesn't have to be reasonable. And so he should have had the message at that point of any lawyer in the whole system. He should have had the message that he needed to pay attention to the court's decisions about money handling by lawyers.
Counsel, can I just ask a question about the Moya charges? I mean, if we were to focus just on the Gore charges and can, examine recklessness with respect to those handling of those fees, does disciplinary counsel see any need for us to address the Moya matters and the Moya funds? I guess more particularly, are there any other cases that are still kicking around where someone took a flat fee or prepayment pre-2009 that, the board would need, or the disciplinary counsel would need the court to explain whether or not there was a retroactive duty to go back post Nance? And did you understand my question?
Yes, I hesitate to speak for the Office of Disciplinary Counsel on this issue.
I understand that you are emeritus,
but yeah, I think as slow as we sometimes are, and as slow as the process sometimes is with all the different players in it, I don't think there are any of those cases still lingering around, and if they are, they probably deal with different issues. So I think we're probably pretty safe on that. There are plenty of knotty problems lurking in this case if the court chooses to get at them, but I do think that a simple answer is quite possible.
Thank you. All right, we will hear from Mr. Schumack again.
Thank you, Your Honor. So with respect to the Gray case, I would suggest to you that they are qualitatively different. In Mr. Gray's instance, he admitted his knowledge of the rules. He admitted that he previously was being compliant with the rules, and somewhere along the way in his practice, he just decided to stop reconciling his trust account for several years, despite knowing that he had the duty to do that. He is losing his appeal based on his actual knowledge and willful election not to comply. The board in Mr. Haar's case has articulated reasons why Haar's conduct was qualitatively different, and we would ask the court to adopt the reasoning that the board used. We certainly agree with the board's reasoning on issues of the reasonableness of Mr. Haar's behavior here. And I don't mean reasonable in the sense that he did nothing wrong. I just mean reasonableness for purposes of determining the dividing line between negligent misappropriation and reckless misappropriation. Beyond that, we would submit on the briefs that we filed with the court, and we thank the court for the time today.
I had one question. I believe that your client testified that he set up his trust account in 2011. Is that correct?
He testified that he opened a trust account. I believe it was on record because his bank offered him a free trust account.
But prior to that, he just didn't have a trust account?
There's nothing in the record on that. Well, actually, I would take it back. I believe
because in the Haar case, in Haar 1, he had a trust account. So I'm trying to understand why he had to open one in 2011.
We do know from the record, I believe it's in the record, that he had changed banks over time. And the bank that he opened the trust account with in 2011 is a bank that offered him a free trust account when he opened his operating account.
Okay. So the record is silent as to whether or not he went for some period of time without a trust account.
That's correct. And the record is also silent as to whether he had a need for the trust account for things like a real estate escrow, as an example. Not that he did that kind of work, but there's nothing to suggest that he had a need for a trust account for any reasons other than what Mance would dictate with respect to prepaid flat fees. This is a lawyer who did immigration work. He worked off of prepaid flat fees, many of which were actually paid in arrears. And by the way,
I thought he testified that most of his fees were prepaid.
He said he usually collected money up front, but many of his clients could not afford to pay the full fee, and they would trickle money in as he was representing them.
All right. Thank you, counsel. The case will be submitted.
Thank you.
I see one counsel has their camera off.
Yes, Your Honor, this is
Is that
Thomas
intentional?
McCauley. Yes, Your Honor, Thomas McCauley, co-counsel with Ms. Conkright. I was told as co-counsel I would not have my camera on.
Just checking. Thank you.
Thank you.
This is our third and final case for the day. It's 19 CV 480, Amos and Jones versus Catholic University of America. Counsel for appellant, when you are ready, please introduce yourself and let me know how much time you'd like for rebuttal.
May it please the court. Good morning, Your Honors. My name is Amos Jones, and I am serving as the person for oral argument on the brief. Joining by live stream are Arenderhit Dali of Dali PLLC, Arthur Hallgood III of Hallgood and Moran LLP, and Sumi Park of Amos Jones Law Firm. I alone will argue, and I would ask that we reserve 11 minutes for my rebuttal. Good morning.
11?
Yes, Your Honor. May it...
Okay, you understand that presumptively you only get 15 to start, so you're giving yourself 4 minutes to start.
That is knowingly and intentional, Your Honor. Yes, thank you.
Very
for
good, thank you. And if
You're
I could ask both counsel for appellee to mute their mics. When you're ready, Mr. Jones, thank you.
Thank you, Your Honors. The facts in this case are not in dispute. This case was severed from a larger employment case that's pending now at the Eastern District of North Carolina Federal Court. The severed count is tortious interference with contract relations. And per the 3 paragraphs of analysis in the Superior Court's opinion, dismissal for failure to state a claim or summary judgment, we simply point out the infirmities in the analysis of tortious interference, especially the intentionality requirement. And we are happy to supplement the record. The facts are not in dispute. Appellant, and I will speak in the third person to avoid confusion. Appellant filed the case timely and asserted that on February 21st, 2017, when the Dean of Catholic University School of Law, appellee, contacted appellant's supervising dean at Campbell University, North Carolina, and then sent a overture letter that in turn allegedly led to the abrogation of terminal year of employment, that this nexus was a tortious interference with contract. We filed a Rule 28K letter, and we're happy to refile a 28K letter after oral argument. The judge below, the court below, is completely correct in calling on the Sidwell Friends case, which is the case that dealt with the third element of tortious interference. The DC Court of Appeals in the Witt case, for which we filed the 28K letter earlier this year in this appeal, that third element is defined in the 2019 Witt case, the supervening authority from this court. Case of first impression on intentionality is defined as intentional interference with that relationship. And our position is that the intentionality is not a criminal type of intent. It's a typical restatement of torts type of intent. That is that the appellees intend to place that, apply those documents to the employer in contract known to appellee, and thereby cause harm to.
Mr. Jones, could you help me concretely, what facts are alleged in the complaint that would support a reasonable inference or would support a plausible claim that the Dean of Catholic, in sending the communication at issue, would have did intend, or maybe short of that, along the lines of Witt, should have been reasonably certain that there would be a later that Campbell would breach whatever contract might exist between you and Campbell? What facts are alleged in the complaint to support inference of knowledge?
In terms of knowledge, 6 paragraphs of the amended complaint found at Joint Appendix pages 10 through 11, and then again, Joint Appendix pages 79 to 80. The trial court ignored these facts as presented in appellant's opening brief. Those facts are, Your Honor, that Catholic University of America on February 21st, 2017, intentionally discussed details of appellant's private application for employment, details discussed with Campbell, without appellant's permission. Within minutes of appellee's conversation with the appellant's boss, then reneged on appellant's contract for employment, the terminal year, by informing appellant that he would be terminated effective May 14th, 2017, a brand new breach of contract on the part of the former.
I get that those facts.
Sorry,
Is that
can I
there
interrupt
was
and
a-
just say we're having sound
Yeah.
problems?
Yeah.
There's a substantial echo. And Mr. Jones, I think it would be helpful if it's possible for you to, when you turn your head, you're not speaking into the microphone. It makes it very difficult to hear you. And we want to get your argument.
Thank you, Your Honor. I hope that this is clearer and without interference. I read for the court's hearing paragraphs 3 and 4 of the First Amendment complaint. And also, I'll just call your attention to paragraphs 361, 362, and 363, and 364. Those are found at Joint Appendix pages 79 to 80. On or about, these are the facts alleged. And remember that under ICMA, which this court follows, we need only show that it's plausible that these acts led to damages.
No, and let me interrupt you there, because the facts that you mentioned concretely so far very much do go to a possible inference, a plausible allegation that the communication caused the breach in question. But what I'm struggling with a little bit more, and you just used the causation language, what has to be plausibly alleged in the complaint is that the Dean of Catholic intended that, or made short of that, would have been reasonably certain that a breach would follow. And that's where I'm not quite sure. Could you explain concretely why the facts that you're mentioning would state a plausible claim that the Dean at Catholic either was thinking, I'm going to make sure that Campbell breaches its whatever contract it may have with Professor Jones, or that at least he should have realized it's pretty sure that if I send this, Campbell is going to breach whatever contract it has with Professor Jones. That's where I'm wondering what facts would make out a plausible, you don't have direct evidence of that alleged in the complaint. So what facts that are alleged in the complaint make that a plausible inference to permit the case to go forward?
In paragraph 362 of the complaint, Campbell University had no legitimate concern regarding the plaintiff's private email communication with the Catholic University of America. Paragraph 363, the private communication regarding a private and personal personnel matter would be highly offensive. These are lawyers and law professors and also a former federal judge in receipt of the material. And then 364.
Can I make sure I understand that? Because maybe I know that there are some questions that were raised about the American Association of Law Schools and what their understandings are, what people should or shouldn't be doing. But just generally, if someone who works at place A applies to place B, and the person at place B knows the person at place A and says, by the way, thought you'd be interested that one of your employees is applying for a position with me. That doesn't necessarily seem nefarious or mean that that contact is intended to or should be foreseen to have the result that person A, having learned that, will breach its contractual arrangements with employee A. So I'm just wondering whether you disagree and you think just the mere fact of that communication is so nefarious that it should support plausible inferences of a kind of a culpable mental state by the Dean of Catholic, or whether you think there are other facts that point in that direction here, or both.
Thank you, Your Honor. I think that it is an actionable event for a person in receipt of a job application to unauthorizedly communicate with the supervisor of the person making application. But the DC Court of Appeals in Witt believes it even more so, because the question of malice and intention to harm is reserved to the question of damages assessment. That's also consistent with Douglas Rosenthal versus Sonnenschein, Nath and Rosenthal, the 2009 case on jury instructions on tortious interference in terms of the malice part. So that's why it's a tort and not a crime. The appellees may have had no ill will. They probably had no knowledge that the recipient of this confidential application material was actively engaged in a total violation of contract and civil rights statutes, we argue, at the time. That's why the law is supposed to provide a remedy for such a tort, an accident, as we say. So when Witt is analyzed as that case of first impression, binding on this court, that unfortunately nobody briefed. It was a 2019 case. This case
Right, but Mr. Jones, if I may interrupt you, Witt, the reason, which had to do with what the proper instruction was to give to the jury, right? But as you say, the instruction laid out what the legal requirement was, and it had to do with whether not so much the evil intent, but knowledge, that the person would know that the interference is certain or substantially certain to occur as a result of his action. And in Witt, what the court looked at was, the evidence had been presented, the factual evidence that the alley was really obstructed, but importantly also that the owner of this beauty salon had in fact complained and told them, this is affecting my business, all the rest. So that there clearly was, again, they were on notice that their activities working on this alley was having a deleterious effect on this woman's business. Specific to the situation in this case, where you have somebody who is an associate professor in one institution and says, I'm an associate professor, I'm on a tenure track, I'm interested in applying to your school, and now I will go beyond the complaint because I read the letter, which goes on at great length about the reasons, and so very well laid out. There is nothing, I take it, or maybe you can tell me, is there anything inherently untoward about somebody who is an associate professor in one university and on tenure track applying for a position elsewhere? I would have thought not. After all, there are visiting professors from other universities. So I'm just wondering what would have put, going back to Witt, what would have put Catholic on notice that merely notifying Campbell of your interest in Catholic would somehow interfere with the existing relationship you had with Campbell University?
The Association of American Law Schools official guidance telling deans and others not to do that, which is cited and exhibited in the record below. That's the indication that reaching out beyond, including references, before a listed reference is checked, one under the ALS, which is the clearinghouse for law school professor faculty recruitment, much like the law school placement in law firms, there are clear published protocols. And the reason that the appellee is the Catholic University of America and not Dean Scordato personally, or not Dean Attridge, the two who are involved, is that at the time of the complaint, plaintiff had no way of knowing exactly who was behind it, but it was a corporate action in a school that is in the American Association of Law Schools that should not be doing that. If the
I understand that there's that guidance in that policy paper, but is it stated there, or is the reason because such disclosure, that confidentiality, privacy is required because it would interfere with existing relationships, contractual relationships?
That's the reasonable inference that everyone draws. It does not state that one who applies for a job could be harmed by his supervisors knowing that he is applying for a job elsewhere. That's axiomatic. It's an inference to be drawn. It's important enough to be in the rules, and everybody's on notice. Also, the restatement that's cited in Witt, and that also the court below cited, comment 766 in section 8A of the restatement, again, supports the view that the act itself of interfering or of going into the relationship is sufficient. These other questions are really things that might have come out one way or the other during discovery, but the facts are pleaded sufficiently under the rules of this jurisdiction in light of the 2019 opinion that properly interpreted Sidwell Friends being relied on by the court below, but not carried out to its logical.
Right, I'm just wondering, now I understand that it's a different standard, that it's this, whether there's knowledge that that the interference is certain or substantially certain to result as a result to result from the action. But that's my question. What is alleged other than the fact that there was a communication without knowing a communication about the application, right? We don't actually have the notice as part of the complaint. The note, the Dear Rich note, it is, and what it says is not part of the complaint. For example, the trial court says, well, it's plausible that they just wanted to say, hey, this person, we're really interested in this person, would like to know your views on his qualifications, his effectiveness as a professor, all those things. What in the complaint kind of push this towards a negative inference?
The appearance of this letter, this private application letter of February 20th, 2017, in the defense position statement of the former co-defendant, Campbell University Incorporated, in April of 2017 at the EEOC. That moment is when the notice came to appellant that there had been this meddling that was harmful, and explained why the terminal year suddenly had been. Tenure was unorthodox in its status. The terminal year, documents in the case in North Carolina now show, was a given all the way up until the time of this interference. In terms of the lack of discovery, to the credit of appellee, They themselves supplied for the court below, found at Joint Appendix 254, the authentication by the IT folks at Catholic University of America, and at 249, 250, Daniel Atridge, Dean of Appellee, Catholic University of America, telling the Dean of Campbell Law School, co-defendant Rich Leonard, in transmitting this application in February of 2017, FYI, thought you would want to know about this. And then it turns up. The other thing in the record, the other, not in the record, but on record, the other piece of evidence is that the General Counsel of Campbell University, who is a co-defendant in this case, is on record as punishing persons, seeking to punish persons who apply for jobs outside of Campbell University. That would not have been known, presumably, to the appellees. That's the purpose of the tortious interference with contract availability under DC law. Nobody should be calling unauthorizedly, particularly with a regulatory framework like the AALS guidance to law professors and deans, and asking about a currently employed person at all. And in this case, we also have the benefit of other materials presented in the forms of Exhibits 5. These are heavily redacted appellees exhibits that are in the joint appendix at pages 129, 132, 137, 143, 258, and 148. And these are heavily redacted communications between appellee and their co-defendants, Campbell University and others. And for these reasons, under the rule of wit, which both the court below and appellees ignored, and under the proper application of Sidwell Friends, which the court below did cite, we respectfully request a remand for at least discovery, because the facts are pleaded in this jurisdiction as they're supposed to be. The 3 paragraphs of analysis dismissing this claim in the 9-page opinion are not recent, or they are not under the recent authority of this court in the first impression case of Witt from 2019.
Well, that's certainly true that the trial court didn't, but we look at this de novo. And so we will apply the correct legal standard, right? As in Witt, and the question remains the same. What in the complaint? What facts, what factual allegations are there in the complaint that would satisfy the standard that is set out in Witt?
And I would simply reiterate those 6 paragraphs cited on page 21 and 22 of the opening brief that were quoted earlier in the argument, Your Honor.
Okay, thank you.
Almost started talking while I was muted. Mr. Jones, we are going to now hear from appellee, but under the circumstances, we let you argue for quite some time. We will certainly give you time on rebuttal, but you can expect that you will not get your 11 minutes because I think you used your time well in your initial argument. So we'll turn to Ms. Conkright.
Good morning, Your Honor. Sarah Conkright on behalf of the appellee, the Catholic University of America, and I'm joined by my co-counsel, Thomas McCauley. The issue before the court today is a straightforward one, and that is whether Mr. Jones has adequately pled a claim for tortious interference with contractual relations. And simply put, there's not been a plausible claim stated. None of the elements of this claim have been adequately pled. But turning to the heart of the matter and to the focus of the Superior Court's ruling, Mr. Jones really has offered nothing more than legal conclusions and conclusory statements to support the third prong, the third element of a tortious interference claim, the intent necessary. And as we've discussed today, this jurisdiction follows the restatement of torts with regard to the law for tortious interference. And comment J to the restatement specifically talks about the different formulations that intent can take. It can be a direct purpose or desire, or it can be actions where there's not an intent directly, but where the actor knows or is substantially certain that his conduct will result in the interference. And simply put, the allegations in this case don't provide any facts that would fit within any of those formulations or allow the court to infer intent under any of those formulations. We have legal conclusions and a very scant set of facts in a 365 paragraph complaint. Only perhaps a dozen or so are directed at Catholic. And those facts are simply that Mr. Jones transmitted a letter seeking employment to Catholic University, that Catholic University communicated that inquiry to Campbell, and that Mr. Jones was subsequently notified that his contract would not be renewed at Campbell. The facts here don't give us any basis to infer that Catholic would have had any knowledge about his contractual relationship, much less an intent to interfere with it. And what you generally see in a tortious interference.
Wait. Didn't the letter say, well, okay, now I'm trying to remember whether there's a pleading in the complaint that says that the letter stated that he was an associate professor at Campbell.
Mr. Jones may have represented that he was an associate professor at Campbell, but that wouldn't allow Catholic to have known that merely
Well, that means he has a contractual relationship, right?
Sure. And the complaint
So-
that Mr. Jones represents in the complaint that his contractual relationship expired on its own in May of 2017. So
Yeah, but that's at the time that this happens, he is an associate professor. Catholic has been advised of that. It's not May 2017 yet.
correct.
This predates that.
That's correct, Your Honor. And Mr. Jones doesn't allege that his current one-year faculty contract was in any way interfered with. In fact, he alleges that he was ultimately advised that that contract would expire per its terms. There's no allegation that that was
the
contract.
on year. It's that seventh year.
Correct, Your Honor. His allegation is that the subsequent year that there was an entitlement to future employment at Campbell University for the 2017-2018 year, and that was where the interference arose. But for purposes of Catholic's knowledge at the time of this communication, even if it could be assumed that or it has been alleged that he represented that he was an associate professor there, there's nothing to suggest that Catholic would have known that he was entitled to any future employment there. And in fact, by sending a letter seeking employment to Catholic for the fall of 2017, he was in fact holding himself out as available and not contractually bound to
Well, that
Campbell.
was my question to Mr. Jones. And so it'll be my question to you. Is there anything that is so inherently illogical or improper, even if you're a professor, if you're a tenured professor, which is what he would have been perhaps the following year, right? Or maybe it was a seventh year, in saying, I would like to be, in essence, a visiting professor at your university?
Mr. Jones is free to contact whoever he wishes and represent that he's interested in employment. I don't believe he identified a visitorship relationship as being the object. And in fact, the letter itself indicates that he's reached his apex at Campbell University and is seeking to make, I believe, a sensible institutional change.
Well, we have to be careful here, because one of the problems with this case is we're trying to look at this as a 12B6 motion. So looking only at the pleadings and the complaint, is an extensive complaint. But there's a lot of references to documents that were really attached to your alternative motion, your client's alternative motion for summary judgment. And those we should not be looking at now, right?
Your Honor, no. However, I do believe that there's authority that would support the fact that the court could consider documents that form the basis of the claim. And therefore, if the court was so inclined, would be authorized to look at, for example, Mr. Jones's February 20th letter. But to your point about what Catholic could have been inferred to know based on that letter that it received in February, at best, the only inference that could potentially be drawn is that he was employed at Campbell as of that date. The fact that he suggests that he's to be tenured, if anything, under Mr. Jones's argument, a tenured professor does not have a contract for terms. And so I think it's
But has a contract, right?
Well, he suggests that the only faculty members who would be under a contract would be a tenured track professor prior to the receipt of tenure.
Shifting back over to the third element, your opponent argues that the dean at Catholic who communicated this ought to have known that by kind of spilling the beans that one of the Campbell employees is out looking for employment without getting the permission from the Campbell employee. I don't mean to, or associate professor who has an association of some kind with Campbell. that was going to create problems, and that everybody knows that, and that in fact the American Association of Law School guidance would have applied to Catholic and reflects a view that that's just it's trouble, and everybody knows it's trouble to pass that information along, and that if you know all of that, then it is a plausible inference that the Dean of Catholic either intended or at least would have known that it's substantially certain that that was going to wreak havoc with the contractual interactions or relationships, current or perhaps prospective, between Professor Jones and Campbell. What's your response to that line of reasoning?
Well, my response to that would be that there's not facts in the complaint that would allow us to draw that inference. There's not facts suggesting that it would commonly be considered improper. There's no facts that suggest that even if it was that Catholic intended such a communication to have any impact on his employment, there's theoretically numerous reasons that that communication could have been sent, but none of the facts in the complaint could lead us to an inference that it was done with an intent to somehow interfere with Mr. Jones's employment. And I think an important point is, in a tortious interference case, the element of intent can often be supplied by an allegation that there would be some sort of benefit or advantage to the defendant from inserting itself into another's contractual arrangement. In a real estate context, the defendant often would obtain the property that was otherwise previously contracted to someone else. In the Costco Marina case, the defendant, the element of intent was met because the defendant was alleged to have held up an assignment contract because he sought a more favorable lease term. There was an upside to the defendant. And in this case, all we have is an allegation that a communication was sent. And that alone cannot supply the necessary inference that there was any intentional conduct that was nefarious or otherwise done in a manner that would have or in a way that Catholic knew or was substantially certain would harm Mr. Jones.
Well, what if the content of the note, as we now know it to have been, had been pled in the complaint? Would that have been a difference? I think you would be interested in this. Isn't there kind of an implication in there that, what's up? What's up with this?
For example, if the email from Dean Attridge had been
Right.
verbatim in the complaint, Your Honor, actually, I don't think it advances the ball at all, because all that says is FYI. It's essentially a forwarded email with no commentary about Mr. Jones, no disparaging statements, nothing that would otherwise suggest any intent by Catholic that Campbell should take any action with regard to Mr. Jones.
Why? Why send it? Why an FYI?
Your Honor, again, there's no facts in the complaint that would suggest any motivation from Dean Attridge.
It's just a complaint, discovery comes after. Why would somebody send an FYI? Somebody's just applied to me. I mean, it can be, as a trial court seemed to think, there could be a completely benign explanation, but there could be a not so benign explanation. And without going into ill will, but of course we also know that there's a context here, right? There's a complaint filed with the EEOC. Deans of universities, I assume, talk to each other about what's happening. I mean, there are inferences that could be drawn. And the question is, why would you send this as an FYI?
Your Honor,
I think you'd be interested in this.
Well, based on the facts that we have before us, it would be speculative to consider the various reasons that the dean would send this.
That was the trial court's bottom line, right? That it would be speculation.
Speculative.
Mm-hmm.
I would like to briefly address Mr. Jones's recitation of several paragraphs in the amended complaint that he pointed out as speaking to the element of intent, and specifically paragraphs 361 through 364. Those speak to the issue of privacy. And, whether Mr. Jones alleges that these were private communications and that he believed them to be so does not necessarily have any impact as to how Catholic viewed them or treated them. And I'd also like to point out that these paragraphs were included under a separate count in the complaint, count 12, which was public disclosure of private facts. And that claim was abandoned when this case was still pending before the U.S. District Court in the District of Columbia. Mr. Jones withdrew that claim. So it was not before the Superior Court when this case was subsequently remanded. And these facts aren't incorporated by reference into count 11 either. And so I just think it's important to know that notwithstanding that, nonetheless, those facts alone do not give rise to any inference that could be drawn to suggest intentional conduct by Dean Attridge or Catholic University.
If the complaint had pled, I applied to Catholic University, I said in the letter, I want you to keep this communication confidential because, I'm being considered for tenure. And then it's disclosed.
That's a different factual scenario. That's
what's missing here. That's what's missing here, and that's what you say the American law schools thing does not supply.
Well, I don't know that it would be dispositive of this question, but it would certainly be a fact that could be pointed to that there was a direction that it should be kept confidential. But here we don't have any allegation that such a communication was confidential or directed to be maintained confidentially. I think you have to keep in mind this is an unsolicited communication from a professor to another institution. Whether there's a one or two sentence reference to these AALS guidelines, but there's no allegation as to what types of communications they specifically apply to, that Catholic University would be bound by them, or that it would even apply to an unsolicited communication as opposed to a communication, employment inquiry that's through the AALS system. And so I don't know that the AALS guidelines would ultimately have a dispositive effect on whether or not a communication could be relayed to someone else.
I'm sorry, are you saying that there wasn't enough pled with respect to the AALS guidelines, or that they don't apply if we were to look at them and interpret them?
I'm saying that there's been a reference to those guidelines in the complaint, but it's unclear what the extent or impact or relevance of those guidelines would have to this specific communication.
It's unclear because the guidelines are unclear?
There's simply a reference to AALS guideline or protocol, not that such a protocol sets forth specific parameters that would otherwise have prevented Catholic University from making this communication. I just think that ultimately we have a communication from an applicant to an institution seeking employment with no expectation of confidentiality, nothing that was not alleged that it was intended to be.
I'm sorry, so I'm still trying to get clear. Are you saying that not enough was pled with respect to the AALS guidelines, or that if we were to look closely at the AALS guidelines, we would say, of course they don't apply to this?
The former, Your Honor. There's simply a
So it's a pleading issue. Well, I say that because I know we recently had a case where there was a reference to another, to a case decided in another jurisdiction and there wasn't much pled about what it said, but we said there certainly was enough there for someone to go and look up the case and read it.
Understood, Your Honor.
Mm-hmm. Okay.
Understood. Well, I'm out of time, Your Honor, but I'm happy to field any additional questions.
I don't have any more.
Judge, sir, you're muted.
I'm muted. So sorry. Thank you, Ms. Konchak. We will now hear from Mr. Jones for just a few more minutes in rebuttal.
Very briefly, thank you, Your Honor. Counsel for appellee is correct when she says, appellant can write to whomever he wants and contact whomever he wants, but appellee cannot. There is a duty of care. That's why the whole tort infrastructure is enforced in American law. That duty of care was breached here. I want to correct a complete misstatement. Every single paragraph of this nearly 400 paragraph complaint was incorporated under count 11, tortious interference with contractual relations, line 353, paragraph 353, plaintiff hereby incorporates as though restated each of the above paragraphs. That includes the references to the AALS guidelines, which were also briefed for the trial court. So these facts in the top of the complaint that might have been related to public disclosure were incorporated in the well-pleaded complaint. I also want to call the court's attention to just the case that the trial court called unlike this one, and that's the controlling case of Casca. That's the full name is here. The Casca case, and I just want to indicate that that case it's in paragraph 3 of the order of the analytical part in the last part. And I just want the court to know that we stand by our position on the applicability of Casco Marina Development Corporation. That factual scenario is very much like this one under the restatement. There are sufficient facts pleaded, but finally, just one statement about how the Witt case has recently been interpreted in the U.S. District Court for the District of Columbia, and I'm happy to provide a citation, but this is an August 2019 case in which Witt is cited as standing for a more lenient view of intentionality in the District of Columbia. And it says that, like the Casca case, which says that a breach is not even necessary to happen for tortious interference to be sufficiently pled, in the case of DC2NY Inc., versus Academic Business LLC, which was at the DDC last year, Witt is cited as making very clear that here in the District of Columbia, quote, instead of the plaintiff bearing the burden of proving that the defendant's conduct was wrongful, it is the defendant who bears the burden of proving that it was not. I would suggest that these hugely redacted attachments that the appellees presented that show their cooperation and that give the full picture of their engagement, further to Judge Ruiz's questions, that that this be remanded for more work on figuring out what's being hidden in these 6 exhibits, 5, 7, these are appellees exhibits, and the joint appendix 10, 12, 14, and C, where there is this cooperation. I can understand the desire to hide things, but we do have a clear record here. It's a fulsome record. And it's just improper that this case would be dismissed. And the rule of law after Witt, after the restatement, is that folks who get employment applications and inquiries can go around calling people without authorization, especially under the official guidance of the ALS. And finally, the American Association of University Professors also have weighed in on, and that's exhibited in this case in the joint appendix, on the harm of abrogating a terminal year. The terminal year, it all became very clear, and we pleaded it as we saw it at the time in December of 2017. But when it all came together, it was very clear. Campbell did their about face, and within minutes of this conduct, within 1 day of this misconduct on the tortious part of Catholic University of America, they destroyed an academic career, because when one loses the terminal year, it's over. And despite 300 applications, the appellant remains insufficiently employed. In the context of an EEOC and federal civil rights case ongoing, in which a law school, Campbell, that does not tenure Black professors and has not extended an offer of tenure in more than 15 years since the one Black person who was tenured left, who's a witness in that case now for appellant, it was a bad context for Catholic University of America to decide to meddle, interfere, disclose, and then cooperate jointly to destroy the viable economic prospects and contract of this appellant. I'm open to any questions or to supplementally brief or to prepare a more specific letter to the court along the lines of that which we provided in April in the transmittal of Witt. Thank you, Your Honors.
You are muted, Judge Easterly.
Doing it again. Thank you, counsel. Hearing no questions from my colleagues, the case will be submitted and this court stands adjourned. Thank you all.
Thank you.
Thank you.